Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. Last Thursday, a special court in Mumbai acquitted all 7 individuals accused in the 2008 Malegaon blast case, including the former BJP MP Pragya Singh Thakur and Lieutenant Colonel Prasad Purohit. The blast, which occurred around 100 kilometers northeast of Nashik, had claimed 6 lives and injured about 100 others. This case has been one of the country's longest-running terror trials, and its accused were first arrested by the Maharashtra Anti-Terrorism Squad, or ATS, within weeks of the bombing almost 17 years ago. One of the accused, a Pune-based businessman, was granted bail in 2011, while the other 6 remained in prison for 8 more years until they were released on bail in 2017. Now, in its verdict, the court said that the prosecution had failed to present cogent and reliable evidence and had not been able to prove guilt beyond a reasonable doubt. And it also noted that there was a strong suspicion about the accused and their role in the blast, but that suspicion cannot be a substitute for legal proof. And so, we are dedicating today's episode to take a closer look at the case, the court's verdict, and the procedural concerns it has raised. And for this, we begin by speaking to the Indian Express's Sadaf Modak, who's been reporting on the case for the paper. Sadaf, can you recall for us exactly what happened on September 29, 2008?
Yes, so on September 29th, 2008, there was an explosion at Bhiku Chowk in Malegaon town, which is about 100 kilometers from Nashik. And the blast took 6 lives and nearly 100 were injured. Most of these were people who had assembled because it was the night of Ramzan, the holy month of fasting for the Muslims, and it was also the eve of Navratri. So the investigator said that the main reason for the conspirators to have chosen this date was to cause internal strife and communal disharmony because it was the month of Ramzan and the eve of Navratri. And 6 people lost their lives and around nearly 100 were injured in the blast.
And talk about who began investigating this matter back then and who all did they initially arrest.
Right. So after the local police, realized that this was a terror attack, the case was immediately transferred to the Maharashtra Anti-Terrorism Squad, which at that time was being led by IPS officer Hemant Karkare. And the probe went on for a while, and the first arrest was made nearly a month later on 23rd of November 2008. And the first arrest was that of Pragya Singh Thakur. And the investigators, the ATS at that time, said that the explosion was due to a improvised explosive device which was placed on a golden colored LML Freedom, which was found at the spot. And they said that they went about trying to figure out who the motorcycle belonged to, and that it led them to Thakur, and that's how she was arrested. She was the first arrest in the case. Following that, they went about investigating her, contacts and who she was in touch with, and they claimed that they found a link to the other accused.
And just for the benefit of our listeners, Pragya Singh Thakur was an activist of the Hindu right-wing student organization ABVP, and later in 2019, while she was still facing terror allegations, she was chosen by the BJP as its candidate for the parliament. She was then elected to the Lok Sabha from Bhopal. And during her term in parliament, she created controversy when she described Mahatma Gandhi's killer as a Deshbhakt. This had caused a lot of outrage. Later in 2024, however, she was not given a ticket by the BJP. Now, when we talk about her, tell us, how was the ATS linking her to the blast? Why did they think it was her motorcycle which was used for it?
So they were saying that the LML Freedom, which was parked at the spot, the number plate was false, but that they said that there was the engine number and the chassis number, which is like a unique identification number of every vehicle. The forensic experts had actually found the erased number, and they had gone to the dealers who sold these motorcycles, and from there they had found that it was registered in the name of Pragya Singh Thakur. That was the investigation that the ATS claimed had led them to Thakur.
And once they arrest Thakur, who else do they find is connected to the case?
Right. So then they had arrested a few more people who were eventually discharged, but they also claimed that their probe showed them that there was an organization named Abhinav Bharat, and they went about arresting some of its members and office bearers, whose members and whose office bearers were under, suspicion. And what they did was they claimed that they had taken permission from authorities to intercept phone calls of these suspected persons. For example, they claimed that, they had intercepted phone calls between one retired Major Ramesh Upadhyay and a serving army officer, Lieutenant Colonel Prasad Purohit. And they claimed that Thakur was already arrested by then, and there was an intercepted phone call between these two individuals where one is telling the other that the cat is out of the bag and Singh is singing quite a song. And they claim that these were conversations which were after there was news already published in the newspapers about Thakur's arrest. And they claim that this conversation sort of showed the complicity of these two persons in the crime because they were discussing what the ATS alleged were conversations pertaining to Thakur's arrest and her interrogation.
And even initially, like you said, ATS was thinking that this blast was done to cause a communal rift and endanger internal security. So after arresting Thakur and intercepting these calls, what do they find out about the motive?
Right. So what they also did was they found out that there were conspiracy meetings which had taken place from 2007 till the execution of the blast in various places in the country, one in Faridabad, Ujjain, Nashik. And what they claimed is that in these meetings, some of the accused had spoken about the need to sort of take revenge from Muslims and planning a blast particularly in a Muslim populated area as sort of like a revenge attack. And they also claimed that this group was speaking about like creating a separate Hindu Rashtra with a separate constitution, a separate flag. These were the things that the ATS claimed came from statements of witnesses who had participated or were privy to these conspiracy meetings that the accused had allegedly attended and participated in. So the conclusion that the ATS drew was that the accused had these motives and therefore they had planned the blast, particularly choosing Malegaon as a Muslim populated area to, execute the plan.
And we understand that after the ATS started investigating this case, they had invoked mcoCA, the Maharashtra Control of Organized Crime Act, which, like UAPA, is an alternate criminal law system. And under mcoCA, confessional statements to the police are admissible in court. So talk about what the police found out through such statements and how key were they for the ATS?
So mcoCA actually is this special act which is in Maharashtra, but it also is now in some of the other states. It's not necessarily invoked in cases of terror, but what it actually means is it's for, targeting organized crime syndicates. So for example, organizations which work in an organized manner to commit crime and to gain a lot of pecuniary benefits out of it. Even though UAPA, which is the anti-terror law, the Unlawful Activities Prevention Act, was invoked in the case, the ATS went ahead and also invoked the mcoCA, which is the Maharashtra Control of Organized Crime Act. Under the Act, confessions given to the DCP are permitted, and the ATS went about saying that there were 3 accused who had given confessions and claimed that in their confessions, again, similar to what the conspiracy meeting witnesses had allegedly told the ATS, they claimed that, the accused had spoken about their roles in the blast and spoken about the roles of co-accused in the blast, including Pragya Singh Thakur, Lieutenant Colonel, and what they had discussed and how, for example, Thakur had offered to provide men for the execution of the blast, and that Purohit had said that, RDX will be provided through him, through his posting in Jammu and Kashmir. So all these allegations they claimed were proved through the confessions of the 3 accused.
Okay, and the ATS began investigating this case in 2008. And we understand that later, the case was transferred to the National Investigation Agency, NIA. When did that happen?
So, in the aftermath of the 26/11, the Mumbai terror attacks in 2008, the NIA was formed, and around 2011, the case was transferred to the NIA, which went on to probe the case, taking forward whatever the ATS had investigated by then. And till 2011, the ATS had filed one charge sheet and another supplementary charge sheet, naming around 11 persons who were responsible for the blast, including Thakur, Purohit, and a few others.
And Sadaf, before we talk about what the NIA's investigation revealed, tell us what were these accused claiming then?
Right. So the accused have since the beginning claimed that the whole case was bogus. They claimed that the investigating officers were sort of carrying out the probe in a biased manner. They claimed that they were tortured. They claimed that, the confessions were forcefully taken. And they also went on to immediately challenge the invocation of the mcoCA, which went up to the Supreme Court. And eventually in 2015, the Supreme Court said that there is no prima facie proof enough to, invoke mcoCA.
And here, Sadaf, talk about the difference between what the ATS was claiming and what the NIA was claiming when it was investigating the matter.
Right. So they went on to challenge it till the Supreme Court, and after the Supreme Court in 2015 said that there is probably no proof to invoke mcoCA, a few months later, in April 2016, the NIA filed a charge sheet, and they sort of agreed with the ATS on some bits of their investigation, but also disagreed with them on some other. So, for example, they said that the mcoCA was invoked without following procedure. So, in mcoCA, you usually require at least one of the accused to have at least two prior charge sheets pending against them so that you can say that it is an organized crime syndicate. In this case, what the NIA claimed the ATS had done is that they filed two cases against one of the accused, Rakesh Dhaude, who was eventually discharged from terror charges, without following procedure. Like his arrests were shown in the previous other cases were shown after he was arrested in the Malegaon case. So that's why the NIA in its charge sheet said that there was a whole process of invoking mcoCA was dubious, and the court accepted that eventually, the special court, and mcoCA was dropped from the case. The main difference between the ATS and NIA charge sheet, if one has to speak about, because the mcoCA was dropped and all the confessions, there were 3 confessions of the accused, they were rendered inadmissible. So whatever the ATS had claimed was evidence that came through these confessions could not be used anymore. And the ATS investigation also harped on Thakur's link to the blast, claiming that it was in her ownership that the vehicle was handed over to absconding accused Ramji Kalsangra, who had then allegedly planted the IED on the vehicle and then parked it at the spot. What the NIA claimed was that Thakur was not involved. She was not using the vehicle for at least 2 years before the blast, and there was no evidence to show that she had participated in any conspiracy meetings or that she had said that she would provide men. And the NIA recommended that Thakur be dropped as an accused, along with a few other accused as well. Although in 2016, the special court, which was, the trial court of the case, said that the NIA's contention that there is no evidence against Thakur cannot be accepted. It said that Thakur should face trial because, the link of the vehicle to her was something that was prima facie evidence, and she could face the trial and then, prove that she was not linked to the case. But at that stage, it said that there was enough evidence to put her to trial. So eventually, 7 of the accused, 6 of them that the NIA also said there was evidence against, including Purohit, went on to trial along with Thakur, who the court, despite NIA's recommendation that she could not be tried, said that there was enough evidence and put her to trial as well.
And this has been one of the longest running terror cases in the country. Could you talk about what we saw take place during the trial?
Right. So the trial began around 2018, and then there was a special court assigned, which was only sort of notified to conduct the trial of the Malegaon 2008 case. There were hearings happening daily, and there were witnesses being examined daily. Of course, during the pandemic years, again, the pace of the trial slowed down. But between 2018 and 2025, there were some 323 witnesses who were examined by the prosecution, which was the NIA. And with the ATS in charge sheet also to be considered by the court, the trial went on with evidence from both the ATS and the NIA charge sheets. And during the trial, however, around 39 witnesses turned hostile. If you remember, I had said that one of the main evidence that the ATS relied on was witnesses who were party to the conspiracy meetings, who had participated in them. Those witnesses eventually told the court that their statements were taken under threat, that the ATS had coerced them into giving false statements. Some of them said that they had been put on gunpoint, illegally detained, and therefore a lot of it regarding conspiracy meetings, a lot of evidence that the ATS had claimed was available regarding the conspiracy meetings kind of came under a cloud because of these statements by the witnesses later on in court.
And we also understand that there were over 30 witnesses who were cited in the charge sheet, but who passed away before they could depose before the court.
Yeah. Because of the time lapse, some of the witnesses who were crucial to the case, they had passed away pending trial. And also the NIA itself, when it filed its charge sheet in 2016, also blamed time lapse for not really being able to gather any evidence from the spot or gather any other fresh evidence from witnesses, given how long it had taken. So the NIA charge sheet, in that sense, did not have any new forensic evidence or any new witnesses. It went about just re-recording, in fact, some of the statements of the witnesses which were part of the ATS charge sheet, claiming that there were discrepancies in it. So, one of the reasons that the NIA has given for not getting fresh investigation is time lapse, and that time lag also did result in, affecting the trial because of some of the witnesses passing away, or, some not remembering what exactly had taken place. So yeah, that did happen.
And now the special court, ended up acquitting all the 7 accused, including Pragya Thakur and Lieutenant Colonel Prasad Purohit, who had been a serving army officer. Talk about the main reasons it did that.
Right. So one of the main contentions of the accused was that the blast never took place. One of the accused had claimed that the blast never took place and it was some another kind of explosion. And therefore, the court had to summon all the injured witnesses, which usually doesn't happen in a trial. And it also had to summon like a kin of people who had died. What the court eventually found, the only thing about regarding the prosecution case that the court did find evidence on, is that a blast did take place. It said that it was an explosive, but there was no evidence to show that it was fitted into the bike, the LML Freedom, or that it was fitted beneath the boot of the bike.
Yeah, which is something that the forensic expert had claimed, right?
Right. So the court said that this claim was based on guesswork, is what the forensic expert told the court, that this was his observation and it was not based on any kind of a scientific test that he had conducted. So the court said that therefore there was no evidence to show that the explosive was fitted into the vehicle, and it said that it could have been just kept somewhere on the motorcycle, or it could have just been like, hung from the motorcycle, and nobody had seen anyone sort of come to the bike, park the bike there, or, nobody had seen the bike being driven from a particular place to the spot. So that was one reason why the court did not agree with the ATS's contention that the explosive was fitted into the motorcycle. That was one of the things that the court did not agree with. On the point of other evidence, since the conspiracy meetings were not proved because of the hostile witnesses, the court discarded that evidence as well. The intercepted calls were one of the main evidences, but the court said that, proper authorization needs to be taken when you are intercepting calls, and it was not done. Therefore, that could not be relied on. Similarly, one of the things that the ATS had claimed was crucial evidence was, so one of the accused, Sudhakar Dhar Dwivedi, the ATS had alleged that he, for some reason, used to record these conspiracy meetings, and the recordings, the audio-video files were found on his laptop, which was seized at the time of his arrest. The ATS had gone about matching voice samples of the people heard in the audio video recordings along with the accused and claimed that they also matched. But the defense claimed that, the whole process of the arrest of this person and the way the ATS had gone about seizing the laptop was not proper. The court agreed that, the laptop was sealed about 24 hours after it was seized from the accused, and this was not proper procedure. It could have been tampered with in that 24-hour period when it was not sent to the FSL but was with the investigating officer unsealed. So that was one reason why the court discarded that evidence as well.
Okay, so just to recap, when it comes to the bomb and its connection to the motorcycle, the court said that we have no proof that the bomb was fitted in. The bomb, could have been near the bike or placed on the bike.
Correct.
When it comes to the alleged meetings that happened in Faridabad and Ujjain, in that, witnesses turned hostile. When it comes to calls which were intercepted, the court said that proper procedure was not followed for you to have intercepted those calls.
Correct.
And proper procedure was also not followed when it came to the police accessing audio-video recordings from the laptop of the accused.
Correct.
But what about the allegations that were leveled against Thakur and her connection to the motorcycle? What did the court say about that?
So it said that the identification of the bike itself was not properly done. For instance, it said that experts had deposed that, the serial number and the chassis number were not properly recovered. And without the serial number, they could not have pinned it down to this particular dealership and Pragya Singh Thakur. Basically, the numbers in the series that the ATS claimed led them to Pragya were not complete. And one of the forensic experts also did say that, while he was trying to get the number which was wiped off, he used a solution which could have led to the whole number getting erased. So the court said, in that case, how is it that they went to the exact dealer who said that it was Pragya Singh Thakur's bike when the serial number was not complete?
And also, what about the allegations against Lieutenant Colonel Purohit? What did the special court say regarding that?
So the main allegation against him was that he had founded this organization called Abhinav Bharat, and that funds were received by the organization and it was used for terror activities. Remember, the ATS had also claimed that it was this organization which was the organized crime syndicate. The court said that there was no proof to show that Abhinav Bharat was involved in any terrorist activity, and that there were allegations that he had procured RDX from his posting in Jammu and Kashmir. The court said there was absolutely no evidence to show that he had in fact, brought any RDX from anywhere or stored it in his house or used it in the blast. So on that front, the court said there was no evidence against him. One of the things that he had also argued as his defense was that he had joined Abhinav Bharat as a military intelligence officer to collect intelligence. And the court said that, that there was no proof of him being assigned by his seniors to join the organization or to collect funds from the organization as an officer on duty. So the court said that although there was no evidence regarding Abhinav Bharat indulging in any terrorist activity, there was also no proof of him having joined the organization, as an assignment or as something that the army had asked him to do. So that the court said there was no proof of that defense that Purohit had taken either. The court also said that there was strong suspicion against these accused, but that there was no legal proof to convict them. So that was one sort of major observation of the court, that there was strong suspicion against them, but it could not take the place of legal proof.
And Sadaf, the other thing is that, there were these 13 statements that were part of the evidence in the case and which actually went missing from the court records in 2016. And they remained missing till the end of the trial. Did the court say anything about that? Did the court acknowledge that?
Right. So in around 2016, it came to light when the trial hadn't started that, there were some 13 statements. Most of them were statements recorded before magistrates, which the ATS had recorded, which had sort of been untraced. And while there was lots of efforts made by court staff, investigating officers to trace those statements, they were never found. They've not been found till date. And those statements, the court said, were crucial in the sense that from what we know, some of those statements were of people who have eventually gone hostile. So the court said that they could have been, asked about those statements. They could have been confronted with their earlier statements that the ATS had recorded, but it could not be done in the absence of the original statements. Actually, law does provide for secondary evidence when something like this happens. In which case, what is done is the defense and the prosecution can agree that the original statements are not available and photocopies can be agreed upon to be admissible evidence. In this case, the court said that the prosecution could not show any proof that these were indeed the photocopies of the original. And the defense also had claimed that they had not received, or either at that time, since they were a different set of lawyers in 2008, 2009, when those statements were taken, they do not have a copy either. So because of that, the court said that that aspect of the secondary evidence could not really be considered because there was no proof that the photocopies available were those of the original.
Now, so far in this episode, we have looked at the timeline of the case and the reason why the court decided to acquit the 7 accused. But now, we look at what the verdict's broader implications are and the lessons it holds for investigative agencies and the state. For this, we are joined by the Indian Express's legal affairs editor, Apurva Vishwanath. Apurva, when you look at this case and the trial and the verdict, where does the problem lie, you think?
So, you look at the 1,000-page verdict of the trial court, and there are a lot of inconsistencies in the investigation that the court flags, right? These are omissions in how the procedure has to be conducted, both actually with the investigation and then subsequent the prosecution as well, right? Which means the lawyers who are arguing the case in court. There are glaring lapses, inconsistencies, and contradictions. So there is a clear case made out for why the acquittal happens. In fact, one way to put it is this is a conviction of the prosecution in the case. The court actually says that the evidence on record creates a grave suspicion against the accused, but there can't be a conviction on mere suspicion, right? That means there is evidence, but the evidence is not brought up to the procedural standards that are required for the court, or they're not corroborated enough for the court to actually convict the accused based on that.
And could you elaborate on this point a bit? Because, the court said that there was a strong suspicion, but there was no legal proof. So what responsibility lies with the prosecution to bring that proof forward, to make that clear in a case like this?
So, for example, we'll start with a simple thing, right? That the initial charge sheet by the ATS was based on the idea that there was a conspiracy by this organization called Abhinav Bharat to sort of plan these attacks in various cities, and you essentially have to prove that there was a conspiracy. And that's how all the conspirators, people who are attached in these meetings or who are part of this, will get convicted, right? So that's essentially the case that the ATS sought to sort of bring about. And the first conspiracy which was allegedly hatched, the charge sheet that was filed had basically the evidence was, there were phone taps, witness statements, basically people who were present in those meetings and said this is what was being spoken about and all that. And there were phone taps between alleged conspirators when they're talking about this. And they found the laptops which were seized of one of the accused. And in that laptop, there were video recordings of some of the meetings, which also show this conspiracy.
And in both these cases, sealing of the laptop and even, the calls being intercepted, the court said that you did not follow the right procedure.
Right. So when this is the evidence, right? So what do you need for a phone tap? That it was an authorized phone tap. That means you had legal sanction to tap someone's phone. So now what happens here is that there are transcripts prepared from these intercepted conversations, but these interceptions are not authorized in that specific period. Permissions were obtained belatedly. So basically that renders this intercepted data unusable as evidence, right? So if it doesn't follow due process, it has to be lawfully obtained. That's like one example. The second example is, when you have a video recording from a laptop, there is something called a Section 65B certificate in the Indian Evidence Act, which is basically any kind of this digital evidence that you have to get a forensic certificate to prove its authenticity, that this has not been altered, doctored, placed in it or whatever. So that was not obtained for a lot of these digital evidences that they had. So these are the things that the court flags and says, look, if it's not the proper procedure, then it is not evidence admissible by a court of law. So all of that goes out of the window. So then how you prove that conspiracy, that becomes really difficult. And the court says, okay, I can't accept that there is a conspiracy here.
And also when compared to the ATS, there have been allegations that the NIA essentially watered down the case and the allegations against the accused. Do we find that to be the case?
So this case, when it began, the probe began in 2008, ATS was going in a particular direction. In fact, the first arrest that they made was Pragya Thakur, who is now a member of parliament. But incidentally, only like days after the first arrest, the ATS chief Hemant Karkare was killed in the Mumbai terror attack incident. So after that, the case sort of is taken over by other people. But 2 years, 3 years later, it's handed over to the NIA, which in the aftermath of that Taj attack, a lot of these terror cases were handled by the NIA. The NIA, when it comes in, it takes a completely different direction. So they take over the case in 2011, but it's not as if any new witnesses were added or, it's not as if the investigation took a different direction. The NIA in fact, just said that we don't have enough evidence against accused number one. So the ATS arrested somebody with lack of evidence is what the NIA said. But it's not as if the NIA brought in more evidence to the table. Only witnesses who were already examined by ATS, they were re-examined. Their statements were recorded again. So, but if an incident happens in 2008 and you're recording their statement again after a few years, there are bound to be lapses in memory, inconsistencies in these statements, All of those, again, form part of why the court acquitted the accused, right? So, in fact, the NIA at one point moved seeking a discharge of accused number one, which is Pragya Thakur. And the court did not allow it. The court said that there is enough evidence to at least bring her to trial. Whether that evidence is accepted, because that depends on, the larger trial, right? Like you have to look at evidence as a whole to be able to convict someone. But the court said there is enough evidence to at least first bring her to trial, and then we'll see where that goes. So the NIA wanted to discharge her, but eventually had to kind of build a case against her and argue against that in court. So all of this sort of is reflected in why the acquittal happens. It's not one reason, but the politics of this case sort of takes over. And when it changes hands between these two agencies, there are glaring lapses which are very hard to miss for the court as well.
And Apurva, are there any lessons one can take from this case, especially ones that agencies like ATS and NIA can take?
Look, I think the first thing is that protecting its citizens from terror is one of the basic responsibilities of the state, right? So when that kind of gets taken over by politics on the shade of terror, whether this is Hindu terror or saffron terror and all of these conversations, then ultimately the trial did get impacted. The way evidence was collected, gathered. In cases like this, of course, there is tremendous pressure, right? Not just in this Malegaon blast case, but any kind of terror case. There is tremendous pressure on the agencies. You have to bring somebody to the fore and say, this is the perpetrator and we've arrested him, to give this sense of security to the people as well. But that cannot be an excuse to have a botched investigation. Because what happens is decades later, when you look back, all of them are acquitted and there is no credible case that is built. So if there is a lesson, it is to ensure that especially cases of such sensitivities, which are so crucial to the safety and security of the country, right? It has to have a higher standard for the agencies, for the prosecution team. And also, in a way, we have to find ways to ensure that there are no inordinate delays. Like in this case, the trial really started only a decade after the incident happened. And now what we have is a trial court verdict. And if it goes in appeal, then there is 2 rounds of appeal and that might take another decade. So plugging all of this, that's, I think, because just 10 days ago, you had the 7/11 acquittal as well. And that's also a case where after 2 decades, you see that there is no closure for the victims who died in these bomb blasts. So the larger lesson is for how we investigate and how we carry these cases to trial.
You were listening to 3 Things by The Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.